All right. So state, do you have any opening statements?
No, Your Honor, the state would waive opening.
All right, defense.
Defense will waive opening as well.
All right, state, call your first witness.
Just formally, the state would like to reoffer all of the evidence from the guilt innocence portion of this trial. Also, the state would ask to invoke the rule, although it's been previously invoked. Just want to make sure that there's no potential witnesses in the courtroom.
All right. With regards to any evidence that's been previously admitted, that will be granted, of course, with all of the objections to remain and the rulings on those objections to remain. And the rule is invoked. State, call your first witness.
State calls Officer Luis Hernandez Blanco.
And could I have both parties approach just for a moment?
Yes, Judge.
All right, state.
Good afternoon, Officer Blanco. Can you tell us what your current employment is?
I'm a police officer with the San Antonio Police Department.
How long have you been employed with San Antonio PD?
6.5 years.
And did you go through any training to become an officer?
Yes, ma'am. I went to the San Antonio Police Department Academy for 7 months.
Okay. And what did you do after that?
Then I did the field training program, which is 3 months, riding with different officers. And then did 2 weeks evaluations. And since then, I've been by myself, police officer, for, I would say, 6 years and 3 months working the same area.
What area is that?
That's the northwest side of town, Prue Road substation. I have the area of 410, I-10, and Fraysburg area.
And what types of cases are you pulled out for?
Regular patrol duties, basically every type of call. Could be murder, sexual assault, it could be loud music calls, or it could be DWIs, any type of calls that a regular patrol officer handle out there.
And were you employed with the department October 14th of 2019?
Yes, ma'am.
How did you get involved with the case on that day?
I was dispatched to a motel in the I-10 Wurzbach area. I was dispatched over there for shot fire calls to cover another officer. When I arrived there, we basically dealt with the shot fire call. We didn't find anything, but when I looked to my right, after I parked, I looked to my right, I observed a white vehicle, and that white vehicle has the doors wide open, and there's somebody passed out on the back seat of the vehicle, laying across the seat. So the legs of that person were outside the vehicle, and another person in the front seat was also asleep. So after we handled the call, the shot fire call, I advised the other officer, hey, let's check on these persons to make sure they're fine. That's the first thought that I had, just check on them. And as I'm checking on them, I realized that the vehicle that they were on, it matched a vehicle that was used a couple of days before for a robbery of a business in my district.
And so how did you recognize the vehicle?
So the day that the robbery happened on that business, I was off, but after I learned of the robbery from another officer, I went to the gas station, to the business, and talked to the clerk who was present during that robbery. He showed me the video of the incident, and he showed me pictures of the vehicle and the suspect and what they were wearing that day. Then when I realized that the vehicle matched the one shown to me on the pictures and the video, then I started investigating the people that were in the vehicle to see if they match the same description that was given to me by the clerk at the gas station.
And who did you find in the vehicle?
I found, Mr. Christie and also Mr. Avery, Tamir Evans Avery.
So after seeing them in the vehicle, what did you do after that?
I approached them, I talked to them, I asked them if they were fine and if they were waiting for somebody. They say that they were waiting for their brother. And I asked them, where is the brother at? And they say that my brother is in room 125. So I go knock on room 125 to see if they know these people outside in that vehicle. And when I knock on the door, Mr. Morganfield opened the door the first time. I asked him, hey, you know these people? And he said, no, I don't know them. So at that point, I was like,
For a second, when you say Mr. Morganfield,
yes,
and what's his first name?
Alexis.
Can you identify him in the room by an item of his clothing?
Yes, he's wearing a black coat with a red accent.
And so that's the person you spoke with at the hotel room that day.
Yes, he opened the door the first time.
And so what did you do after you came into contact with him?
So I asked him if he knew them, and he said no. So I went back to my vehicle. I verified the license plate of the vehicle. And based on the license plate return, I had a name and a last name for the vehicle owner. So I verified that name and last name in my computer. I was able to get date of birth, verify the date of birth, and I got a match for the owner of the vehicle. And also I observed that he have a theft warrant, a Class B theft warrant.
So who was it that you identified to be the owner of the vehicle?
Alexis Morganfield.
And so once you found out that there was a warrant and he was the identified owner of the vehicle, what was the next step in your investigation?
At that point, I talked to the other officers. I told them that we need to go make contact with this person again and try to get him in custody for the warrant. So I knocked on the door and another person opened the door. At that point, it wasn't him. And I asked him, hey, where is Mr. Morganfield? And he said that he's asleep. When I looked, the room was set up with 2 beds in the room. I looked in the room and on the floor, I observed numerous preservatives, and then there's condoms, used condoms on the floor of the room, and then the 2 beds.
I'm sorry, I'm just going to interrupt
Mhm.
briefly. How did you know that they were used?
Because they were out of the wrap and they were basically prolonged. Yes.
Okay. Okay, so did you observe anything else in the room?
Yeah, there's the gentleman that opened the door at this time, Mr. Morganfield, who was on the right side of the room, on that bed on the right side of the room. And then I observed 2 more people underneath a blanket. They were laughing at that point, so I didn't really pay a lot of attention to them. But I saw 2 more people on that bed on the left side.
And
Bed.
were these 2 people female or male?
Based on the way that they were laughing and talking, they were females. I recognize the voice to be females.
And can you describe what Mr. Morganfield was doing in the bed?
And when I knocked on the second time, he was laying on the bed, facing down, pretending that he was asleep, basically.
Do you remember if he was dressed?
Yes, he was dressed.
Okay, and what did you do after you observed the room?
So I basically went in, grabbed him, detained him, and exited the room. I left another officer at the room doorway so he could maintain the door open to make sure nobody else goes out or in to that room. Basically, I detained Mr. Morganfield. I detained the person who opened the door because I didn't know that person was actually involved in the robbery as well. So I detained everyone. And then the detective that was at the doorway, he called out the two people that were in bed, the two females. At that point, we learned that one of the females was 14 years old and the other one was 16 years old.
Those two females were the females in the bed across from Mr. Morganfield's bed.
Yes.
And so what was the next step in your investigation?
So at that point, we detained everyone because we had the suspicion that it could have either sexual assault taking place at that time, or it could have a human trafficking case. And also, we needed to make sure we contact the robbery unit and everybody else. Also, we needed to get the parents of those juveniles to the scene to figure out if they knew where they were. So we held everybody in place until we got in contact with everyone that we needed to.
Were you able to make contact with the juvenile girl's parents?
Yes, we did.
And were they ultimately picked up by their parents?
I'm sorry?
Were they ultimately picked up by their parents?
Yes, they did.
Move that screen.
This-
Okay, so while you were investigating everyone and how they were related to the different offenses, where was Mr. Morganfield?
He was sitting in my patrol vehicle.
And can you explain what you were doing as part of your investigation?
So I had to contact my supervisor based on the type of offense that I have believed that I had at the time. I had to contact my supervisor to advise him of the incident, and he made the location as well. Then I contact the night investigations detectives. And by that time that I contacted them, it was almost time for them to go home. So what they do, they pass along the information to the incoming shift, which is the sex crimes detectives. They get there around 5 in the morning. So I had to wait for them to get there and then wait for them to make the scene because of the possible sexual assault of the child or the human trafficking case. So at that point, I wait for them to get there. Obviously, while that's waiting, we start processing the scene, taking pictures of the vehicle because of linking it with the robbery. Also trying to link the clothing, which we found the matching clothing that was used on the robbery. We found it in the vehicle, and also some of the items were in their possessions as well. Mr. Morganfield vehicle, and they're wearing, if I don't mistake, Mr. Morganfield has some of the clothing, and the other gentleman has some of the clothing as well.
And the clothing that you're talking about, is that clothing that was taken during the robbery?
It was, no, it was, they were wearing it during the robbery.
Alleged robbery. There's been no proof of a robbery. Sims fact's not in evidence, Your Honor.
Sustained.
And can you tell me about what time of night you arrived at the scene?
We arrived around 4:30 in the morning, around that time, yes.
And about how long did you remain at that scene at the hotel room?
I would say around 7:15, 7:20, something like that.
And you explained that that was partially because there was a change in shift.
Yes, change shift, and then we had to process, get a CSI to the scene, and we had to interview everyone, including the parents of the juveniles as well.
Can you explain what is CSI?
CSI is the person who collect the evidence and process evidence.
And do you remember about what time you actually left the scene?
The exact time right now, no on top of my head.
Can you estimate about how long it was before you left the scene?
I would say probably 3 hours or so, 3 or 4 hours.
Is that pretty typical for that investigation?
For that type of investigation, yes, ma'am.
And were you wearing a body worn cam at the time?
Yes, ma'am.
And you also, were you driving a vehicle
Yes, ma'am.
of your own?
Mhm.
And that vehicle was assigned to you?
Yes, ma'am.
Did that vehicle have a recording device in it?
Yes, ma'am.
And what does it record?
It records the front of my vehicle. It records the back seat where I have the prisoners as well.
Okay, and is it capable of making audio and video recording?
Yes, ma'am.
Showing you what's been marked as State's Exhibit 13. Do you recognize that disc?
Yes, ma'am.
And were you able to watch the disc?
Yes,
Did you recognize the voices on the disc?
yes, ma'am.
And can you describe the voices that you heard?
It was Mr. Alexis Morganfield and myself.
Was the audio and video an accurate reflection of what you remember from the time of the offense?
Yes, ma'am.
Did it look like it'd been altered in any way?
No, ma'am.
I'm offering State's Exhibit 13 to defend.
Is this the incorrect event, Officer Hernandez? Your Honor,
Yes.
defense is familiar with this. Defense is aware that this recording is 4 hours, 54 minutes and 51 seconds in length. And
Do
we
you have a legal objection?
do not have a legal objection. We have an objection to showing an excerpt of this that does not show how long my client was in the car before he was transported. Because in order to get context, it is important that everyone know how long he was in
So
the
there's
car.
no legal objection.
There is no legal objection.
So there's no objection to State's Exhibit number, what number?
13.
All right, then State's Exhibit number 13 is admitted.
Judge. Can you send this page to mine?
Your Honor,
Yes,
defense needs to approach.
yes. Ladies and gentlemen, I'm going to give you a 10-minute recess. And remember, you're not allowed to deliberate until I give you the instructions to deliberate, and you're not allowed to do any research. Does everyone understand? All right, so we'll be back at 2:20. Will that give everybody enough time? All right, everyone, please rise for the jurors. We're not on the record. Are you Miss Morganfield? Are you Miss?
Yes.
Ms. Morganfield? All right, can you come forward, please? All right, so I know that moms have concerns about their children, right? He's been taken to the back. There's banging on the back. He's the only person back there. And so I want you to know, nobody has harmed him or hurt him. Your counsel, the counsel for your son asked for a short break so they can explain to him as far as what's coming in and why it's coming in. But it appears that he doesn't want to hear that. So this trial is going to continue. Punishment may continue without him. I would hate for him to be brought out strapped down, which is what will end up happening. Because the deputies don't want to bring him out because things may happen. So that's where we are. And
We are very much looking forward to a vigorous cross as soon as it's our turn.
okay, well,
Do you think talking to your son is gonna help calm him down? That's what I need to know.
well, the only thing is I don't know if the deputies would allow you in the back or not. All right, Deputy Mahia, Deputy Laura, is it?
We need to set it.
All right, so, but we're not, he's not going to be released from the cell.
No, he's inside the cell.
Okay, so he's inside the cell. So that this trial can continue. I'll allow you to go back there, but you're gonna have to leave your purse and everything out here. You can leave it there. No one will bother it. And yes. State, do you have any objections to her speaking to him?
Absolutely not.
Okay.
Your Honor. So that's your call.
Real talk. How y'all expect me to feel? I've been calm this whole time and all of this stuff happening to me. Y'all just don't understand where I'm coming from.
Excuse me, Mr. Morganfield. Here's the thing.
Yes, ma'am. You can please.
There
let
are
me know.
proper ways
Mhm.
to act in court. And part of the ways to act in court is, number one, when there is a witness testifying, the state is questioning those witnesses, then your counsel will get a chance to cross-examine them. I'm going to tell you what I've told plenty of people before who've been in my court, and when I've had people as clients as a defense attorney. Going to law school is not something that attorneys do just because they're saying, let me just go to law school. It's required. And both attorneys for the state and the attorneys for the defense are expected to know the law. You are asking me to remove those items for you, but you've been behaving inappropriately. I heard the knocks on the cell back there. That's not appropriate behavior for court. Do you understand?
I was just upset. That's all it
No,
is.
no. Listen to me.
You know, they
Listen
can
to me.
say so.
Listen to me.
Pity.
Listen to me. One, I allowed your mom to go back there and speak to you, and I could still hear you shouting back there, not listening. The reason why you're in cuffs is for your safety as well as everyone else's safety. Do you understand?
Yes, ma'am.
So you have questions that I need to know the answer to.
Please, can I tell?
Well, and here's the thing, either you want to remain in court and have your attorneys get a chance to cross-examine witnesses in your presence, listen to the state, do they direct examination in your presence, or either you do not. If you are disruptive and behaving inappropriately, what will end up happening is you will be taken from the courtroom, or number two option is going to be you will be presented in front of this jury, bound and gagged. Do you understand?
Can I?
No, here's the thing. I'm not your defense attorney. In this situation, I'm the judge. The choice you've made has been, if you were found guilty, to go to the jury for punishment. So that is what has happened. No, wait, that is what is happening now. So the state will present whatever witnesses they wish to present. And for want of a better term, just so that you can understand, punishment is usually wide open. And when I say that, what I mean by that is the state presents any witnesses they believe to give information to a jury about what would be the appropriate punishment for you. And your counsel gets to call whatever witnesses they deem is something that the jury would be able to hear to make a determination on what calm down, make a determination on what the appropriate punishment will be. Now, I know sometimes that people don't understand. I've only been tried for this one case. Why are people bringing up other things that I have not been on trial for? Because it's punishment. And the jury gets to decide whether or not whatever extraneous, because it appears that this witness may be here about some sort of evading. Is that correct, State?
Retaliation, Your Honor.
Retaliation. So he's here about retaliation. Once the state questions this witness and the defense cross-examines this witness, if that is the only witness that the state will call about retaliation, then a jury will get to decide whether or not they believe that witness has proven the retaliation extraneous offense beyond a reasonable doubt. That's the way the law works. And what I'm explaining to you here now, I usually don't do, but I find that communication sometimes help people understand. What I do know is your mother shouldn't have had to come in here and talk to you in the back to get you to calm down. You understand?
Yes, ma'am, I understand.
All right. So do you want to be a part of this punishment phase of your trial? Yes or no?
Yes, ma'am.
All right. Now, are you going to behave appropriately?
Yes, ma'am, I'm going to behave. I was just can't believe how they trying to do that in front of the same jury. That straight big.
Well, because that's the law. Here-
Stuff.
Here's the thing, Mr. Morganfield, here's the thing. I'm here sitting, listening to the witnesses just the way you are. And my job is to call a ball and a strike. So whatever objections are raised, I will make a decision on those objections. But I've just explained to you what comes into evidence during a punishment phase of a trial. You understand?
Can I tell you something on this?
As long as it is not about what you perceive to be your character or the facts of the case. And I say that because I'm sure your attorneys don't want you addressing anything that has anything to do with what you believe the facts of the case to be.
Hey, look, miss, I got upset because they trying to bring up with some girls. Like I'm already going through a case about a girl to the same jury that I thought I was going to be.
All right.
Jury.
All right. I understand what you're saying, but what I'm telling you is during punishment, extraneous offenses. And when I say extraneous offenses, I mean offenses that maybe you have not been found guilty of, offenses that maybe have not been indicted by the district attorney's office. They get to call witnesses as long as your counsel has been given notice of it. So for example, if you littered yesterday and the state wants to call in witnesses, this case is not about littering. It's not about spitting on the sidewalk. But if the state wants to call a witness that says you littered or you spit on the sidewalk, they can call that witness for this trial. And then the jury will make a determination of whether they believe you littered or you spit on the sidewalk. So basically, a majority of things come in during punishment. Do you understand now?
I don't understand. So everything they doing is legal.
What I can tell you is normally everything comes in during punishment so that a jury can make a decision on whether what your punishment should be. Now, what ends up happening is, as it happened in the guilty, not guilty phase of the trial, the defense can make whatever objections they want to make, and I will rule on those objections. But what I'm telling you is punishment, pretty much a lot comes in during punishment. I don't want to say everything comes in during punishment because I don't know what evidence is going to be presented in this case. But what I can tell you is if there's an extraneous offense, and I've explained to you what an extraneous offense is, if there is, the state can present witnesses to try to prove up that extraneous offense in punishment.
Even if the case that I'm going through though is pending, like basically what I'm saying is I still got to go and handle that case right there. They're basically.
Well, let me
right here with that juror that just straight convicted me. No, just straight guilty.
Yes. And I'm going to speak to you in hypotheticals. If John Doe is charged with robbery, let's say John Doe has 3 robberies he's charged with.
Yeah.
And he goes on to trial for one of those robberies and he's found guilty. the state can present evidence in punishment if they've given notice to the defense of those other alleged robberies. And they can call witnesses, and then the jury can make a decision on whether or not they believe that the other robberies have been proven beyond a reasonable doubt. And they can base their decision on punishment from what they hear. So that's the law.
Okay, well, I accept everything you said. I'm sorry, miss. You can please take this off. I was upset because I've been going through too much with this little stuff like this. You know what I'm saying?
Well, I mean, it is,
Mad quick. It's not like I don't know what I'm doing. Very intelligent. It's just, I just get mad, you know what I'm saying?
Mhm.
But I can't do nothing. I'm behind the wall.
no, here's the thing. So, defense, do you want to speak with him and see if he's proceeding with punishment before the jury?
Yeah, I'm proceeding with punishment.
You want to talk to them, talk to him? Yes. Or Deputy Mejia, do you want to keep the cuffs on? Do you feel that's best for now?
Yes.
All right. So the cuffs are going to remain on for now.
You cover them with this suit, pardon me?
Yes.
Judge, we think that'd be highly prejudicial. I'm the one that's sitting next to him.
That is true.
I mean, he just needs to hide the handcuffs, and we'll see how he does. And if he proves that he can remain calm, then the jury won't see him. And what I can do is when the jury comes in, everyone just remains seated. And what I'll tell the jury is everyone is remaining seated because I request that they remain seated. And I'll say something because of the microphones. So that way they won't know.
Your Honor,
Yes.
could we request for the record that Mr. Morganfield be uncuffed at this time?
Oh, we can go on the record. All right. You're requesting that he be uncuffed. Is that correct?
Yes, Your Honor, due to the prejudicial nature, and he has assured the court that he will be calm.
All right.
Just wanted to
So.
put it on record.
All right, thank you. So that will be denied. And so that the record is clear, Mr. Morganfield became disruptive in the courtroom. The court took a recess at approximately, I believe it was 2:13. And I told the jury that we will be back at 2:20. And I allowed Mr. Morganfield's mother to speak with him. The deputies took Mr. Morganfield back in the holding cells. Mr. Morganfield was banging on the holding cells, being disrupted from the back. Both defense counsel thought that his mother would be able to calm him down. His mother was allowed to go into the back. I could still hear yelling from Mr. Morganfield in the back. And we are here at 2:46. And the reason why we are here at 2:46 is because it took 20 minutes for Mr. Morganfield to come down. So the court will have Mr. Morganfield remain with handcuffs on. If Mr. Morganfield is able to not be disrupted with the handcuffs on, then the court will consider, of course, with input from the deputies who are in charge with security, whether or not they should be removed. Off the record, the court has been informed, both the state and the defense and Mr. Morganfield, that they are to remain seated when the jury comes in so that the jury will think there is no disrespect to the court or them. The court will instruct the jurors that I have asked both the defense and the state and Mr. Morganfield to remain seated for technical, logical reasons. And for the record, from here, you cannot see that Mr. Morganfield is handcuffed because his shirt is covering the cuffs.
Judge, he also has leg restraints on also, which I think the jury will see.
So now,
And the
All
shirt
right.
is not covering the
This
cuffs.
judge, yes, I'm clearly know what I'm doing.
Yeah.
I'm sorry.
All right, Deputy Mejia and Deputy Laura, with regards to the handcuffs to the legs for courtroom safety, do you believe that those should remain?
Yes, Judge.
All right, those will remain. Mr. Morganfield, you will just need to put your legs in between the two legs of the desk.
We put a box underneath it, maybe to hide it.
Yes. Yes.
Judge, can I say
And so for the
something?
record, the wooden cabinet is being moved in front of Mr. Morganfield's legs. And the jury will not be able to see his legs. It rolls, Mr. Cantrell.
Judge Ward, when you have to say something, please.
No.
Ask question.
No. All right, we're going to bring the jurors in. And Mr. Cantrell, are you able to see from the jury box?
It doesn't appear that
Until they can see it, no pending cases.
All right, so
unless
for
they
the,
really try.
all right, so for the record, Mr. Cantrell has walked to the jury box and he has stated that the jurors will not be able to see the cuffs on the legs of Mr. Morganfield. Yes, excuse me, the witness, if you could come back to the stand, please. All right, we're ready. Yes,
All right, the jury.
except for you all. Yeah. You all remain seated. All right, everyone, please be seated. All right, I'm sorry, our break turned in a little bit longer. As I said before, I have other matters that I have to take up whenever I leave, whenever I have you all leave. Sometimes it's not about this specific case, it's about the docket I already have. I'm asking that the state and defense that they remain seated because we've been having a little bit trouble with the microphones and everything. So we got them set up just right now. And sometimes when you touch them or tap them, then things get disconnected. So they're not being disrespectful by not standing. I've just requested them not to do that because that will help the court reporter. And then we don't have you all waiting in the box and there's some issue, okay? All right, state, you may continue.
When you publish the jury seats.
All right, that'll be granted. Thanks. Don't touch the microphone on the way back.
Additional pieces. Sorry, Judge, we're- technology not being very.
I know, sometimes it just doesn't want to work. State.
I'm sorry, Judge, we saw we had it queued up and I will,
Well, we're being, I'll just ask you a couple of questions. When you finished your investigation, what was your next step?
So after the investigation at the scene was done, I was directed to take Mr. Morganfield to the robbery unit for an interview. Also, Mr. Christie was taken over there, and Mr. Avery was taken over there as well for an interview with the detectives.
And during the time that Mr. Morganfield was in the backseat of your vehicle, was he handcuffed?
Yes, he was handcuffed with two handcuffs, so it was more comfortable for him.
And how does that work?
So you have more room. When you have one handcuff, you can have your hands like this in your back, and that's the room that you have just to move. Versus when you have double handcuff, you usually have this amount of room, so you can move your arms are more freely, and you are not squeezing your arms with your back.
And do you usually put two handcuffs on individuals?
Yes.
And what was the purpose of him being handcuffed?
So at that point, he was to be detained until the investigation was completed. Also, he was under arrest for that warrant that he has. So we still have to get him in custody at that point.
And when you started to drive, where were you going?
I was going to the robbery unit.
And you asked him to fill any questions on the way?
No that I can recall.
And did Mr. Morganfield make any statements?
Yes.
Do you remember what those statements were?
Yes. Some of those statements were basically quotation. He was telling me, "Trust me, my nigga, I beat your ass and I will sue you. You're gonna know why. They call me Big Slunk nigga. I wish you will try to test me and pull me over somewhere. I will knock your ass out. You're lucky that you are a police officer, because if not, I will knock your ass out again. I hope you touch me when I go to jail so I can knock you out." Also, he kept saying that he will lay me down and he will take a charge for doing it.
And did you respond when he was making those statements to you?
No, the only thing that was that I told Mr. Morganfield was to calm down, because if he doesn't calm down, I will have to call the wagon to the scene so that he can be transported in the wagon. The wagon is basically where we place prisoners when they are acting in a way that we can't, for the safety, we can't keep them in the patrol vehicle because of the confined space. Okay, the wagon has more room. It's basically a van that is designed to transport multiple prisoners.
It was the purpose of getting a wagon from Mr. Morganfield, was it just because of the verbal threats that he was making?
No, because he was kicking the cage. He was hitting the cage with his head. He was trying to punch stuff around the vehicle, and I was afraid that he first would hurt himself, and second, he will damage the vehicle as well.
What did you perceive his statements to mean to you?
I feel threatened at the time. I feel that he was threatening me to hurt me or to look for me after he gets released from jail to basically commit an act of violence against me.
And why did you think he was going to look for you?
Because he made the statement that he will look for me to basically hurt me.
Is you drunk or high or?
And you recognize this video to be the backseat of your
Yes, ma'am.
vehicle?
You're a kid, man.
Fucking kid, big bro. Man, look, sir,
Take a seat. Let me check that out really well,
And
okay?
then, sir, with the ticket warrant, sir.
Okay, check that out.
Who do you recognize that to be?
That's Mr. Morganfield.
And is that when you first put him in the car?
Yes, ma'am.
So you put him into the car at about 21 minutes into this video,
Yes.
and he remained in the car from that point on.
Yes, ma'am.
How did you even know that? You know what I'm saying?
Nah, cause they be on alert. This boy slumped out the car, so they like, what
Man,
the hell?
I know how to do my job. It's not my
Yeah, I
first
know, me,
rodeo.
I'm good though. Good.
It's not my first rodeo.
I'm already knowing how they be peeping out the room.
gonna move it forward. Sorry, it's just frozen. Did he, while he was speaking to you,
I'm sorry?
did he call himself any type of name when he was speaking to you?
Yes, he say I guess his nickname was Big Slug, something like that, something similar to that.
Say what that meant?
Basically, he made a statement about that. He said that they call him that because whenever he's a boxer, and whenever he punch the people or swing at them, he knocked them out. That's why he's called Big Swung.
Okay, and did he tell you anything else about his boxing?
He say I got 46-0 record, 16 knockouts, and he says also that I'm a boxer. I'm sure if I get you there, I would knock you off.
Did he mention anything about taking a charge?
Yes, he said that he will basically what he say over here is I lay your ass down and I will take the charge for it.
And about how many people have you arrested during your time on the police force?
Wow. I would say probably between 400 to 600.
And have you ever been threatened before?
Yes.
And have you ever had to write a report for retaliation?
Yes, ma'am.
About how many times?
Around 6 times.
So out of all of the people that you've arrested, you only felt the need to write a report for retaliation about 6 times?
Yes, ma'am.
And this was one of them?
Yes, ma'am.
And why do you feel it was important to file this case?
Because of excuse me. I think it was important to file this case because of the first threats that were made towards me and basically other officers, and also because of the aggression that he's shown during the time that we had that interaction.
Were you in fear for your life?
Yes, ma'am.
Were you in fear for your family's life?
Yes, ma'am.
Defense?
A few questions for you, officer. It's Hernandez, right?
Yes, sir.
Now, you had originally gone to a hotel. You said it was originally something to do with a fire alarm call. Didn't you say that?
No, it was a shot fired.
Oh, shot fire. Okay,
yes.
okay. But you never found any firearms with my client, did you?
No,
Mr. Morgan,
no.
you never found any firearms. Okay. And you never found any firearms in his room, did you?
no, sir.
And when you went into his hotel room, you saw multiple people in there, didn't you?
Yes, sir.
Okay. You said you saw what appeared to be used condoms.
Yes.
So who did the DNA come back to?
We don't do the DNA for that.
You don't know, you cannot say with any confidence that any of those condoms were used by my client, can you?
No.
And there were other males on the scene, weren't there?
Yes, sir.
Okay. And not a single female that was there admitted to any kind of sex, did she?
No.
So nobody admitted to anything more than possibly marijuana, did they?
No, sir.
And you said that you were investigating, that there was something about a robbery investigation.
Yes, sir.
Mr. Morganfield has never been convicted of robbery, has he?
I don't know, sir.
But you don't have any knowledge that he's been convicted of that.
I don't know, sir.
And you're aware that everybody is presumed innocent until proven guilty. You've heard that before, haven't you, officer?
Yes, sir.
Okay. You also said that there was a misdemeanor, and you specifically called it a misdemeanor. You said that there was a misdemeanor theft warrant,
Mhm.
and you were serving that misdemeanor theft warrant. Okay.
Yes, sir.
Has my client been convicted ever of theft? Do you have any knowledge whether he's ever been convicted of any theft?
I don't know, sir.
Okay, so you can't prove that he has been convicted of any theft case at all.
I don't know, sir.
Okay.
I can't
You
give you the
can't
answer.
prove that before this week he has ever been convicted of anything, can you?
I don't know, sir. I can't give you the answer.
So, to your knowledge, nobody admitted to sex at that scene. To your knowledge, no DNA testing was even done, was it?
No, sir.
And you did mention in your testimony that there was a long wait. I think you said something about a shift change or something
Yes, sir.
because it was late night getting toward morning. Is that,
Yes,
is
sir.
that fair?
Yes.
So it was dark when you got there, wasn't it?
Yes, sir. It was.
But by the time you actually started driving Mr. Morganfield, it was light, wasn't it?
Yes, sir.
Okay. Now, you mentioned he got upset and that you threatened to put him in the wagon. Do you remember saying that?
That's not a threat, sir.
You said something about having to put him in a wagon or having to call a wagon. Is that a fair statement?
Yes, sir.
Whatever the right words are.
Yes,
Okay.
sir.
Now, you were kind enough to explain to the jury what the wagon is,
Yes, sir.
but you didn't explain to Mr. Morganfield what the wagon was, did you?
I told him, calm down, or I'll have to call the wagon to transport you.
But you didn't say to transport you, did you? You just said, I'm gonna call the wagon.
That's what I say, sir.
And if he didn't know what the wagon was, then you can't really say what might have been going through his mind when you offered to call the wagon. Could you? I mean, you couldn't read his mind.
I can't
and you
speak for
didn't
your
explain
customers,
the
sir.
wagon.
I can't speak for.
It is true, isn't it, that from when you first placed Mr. Morganfield in the patrol car until you started driving, it is true that more than 4 hours elapsed, isn't it?
What I believe, yes.
And this was October 16th, but he was shut up in the back of a cop car. Do you recall whether you had the air conditioning on?
It was October 14,
Yes.
and yes, I had the air conditioning on.
Okay. And the air conditioning was on. Do you recall Mr. Morganfield asking you for his jacket?
He asked for his jacket. Yes, sir. He did. Mhm.
Multiple times, didn't he? More
Yes.
than once? Okay. But you didn't get the jacket for him, did you?
Can I explain you why not?
No, not
Okay.
this time. Just
No,
either
sir, I
you
didn't.
gave him his jacket, you
No,
had
I
the air
didn't.
conditioning on. Sorry,
can only take one.
I apologize. You had the air conditioning on. He was
Mhm.
sitting in there for 4 hours, cuffed behind. He
Yes.
asked for his jacket multiple times. You didn't give it to him. That's all I'm asking. So
No,
you-
sir.
you've told me you didn't give him his jacket.
No.
Okay.
Okay.
Now, you said that he made reference to a special name. Do you recall anything about the name Big Slime? Is that what you recall hearing?
He said big is long.
Big Slong?
Yes.
Okay. Does that have any meaning to you whatsoever?
The way that he explained it to me, yes.
What was the meaning that it had to you?
Basically, that he is called that name because he is knocking people down every time that he's swinging at them.
Okay, okay. And you got that from context or because of the way he pronounced?
Because of the way that he pronounced
Okay.
the word.
That's fine. Thank you. Now, during these 4 hours, he was waiting. He didn't get any water to drink, did he?
No, sir.
And after you threatened, okay, threatened is the wrong word, after you said you might have to get the wagon. He talked to you several times, prefaced by, if you touch me wrong. Do you remember hearing that?
Yes.
4, 5, 6 times?
Yes, sir.
Does it seem weird to you that after you threatened to get something that you didn't explain, that he would keep talking about, if you touch me wrong, as if you had threatened him or miscommunicated to him?
No, sir.
And these 4 hours, he was handcuffed. You said it was double cuffs, but he was still handcuffed in his back, right? Behind himself. So if he needs to scratch his nose, too bad, right?
As you can see in the video,
Okay.
he was handcuffed, but he was moving his arm to the front because the double handcuff allowed him to do that.
Did you notice during his rant, we'll call it a rant, it was what it was. Did you notice during his rant how he kept conditioning what might be threats? If you touch me wrong, if we were on the street, if you get me out of this car. Did you catch all those conditions that he gave on the video to keep from giving you an actual threat? Did you catch that?
No, sir.
Did you ever have any reason to believe that he was a boxer? Anything about the situation that would give rise to any kind of an inference that he was actually a boxer?
Other than him saying, no.
If he was 46-0, then everybody would know about him, wouldn't they? I mean, stands to reason,
He could be amateur. He could be
even with
I'm sorry?
amateurs. Okay.
amateur.
Amateurs.
Yes.
I want to focus on the word wagon. Now, the way you pronounce, and again, the way you talk is totally fine, but you pronounce it wagon. Is that correct? I mean, is that fair?
Yes, sir.
Okay. Is it possible? This is a stretch, but is it possible that Mr. Morganfield could have heard you say, I'm going to put you in a wagon?
Objection calls for speculation.
Is it possible? I simply want his lay opinion if it's possible based on his conversation, based on the way he pronounced the word.
All right, that objection will be sustained.
Is there anything about the way that you said you were going to put him in a wagon that could have led him to believe that you were going to put him in a wedgie?
Objection calls for speculation.
Sustained.
Withdrawn. So you were transporting him to robbery unit simply because he was wanted for questioning at that point. There
Yes,
was
sir.
no robbery warrant, was there? At that
No,
time?
sir.
Okay, he was wanted for questioning.
Yes, sir.
And there was a warrant for a misdemeanor theft case that, to your knowledge, has never been convicted.
I don't follow those
You were
cases,
just
sir.
you were just taking him in because you saw a misdemeanor warrant and he got arrested.
Exactly, sir.
Nothing else. Okay. Okay. So one last thing I'm trying to still wrap my brain around. When you went for the shots fired call, you found a vehicle open in the parking lot. What gave you the right to enter my client's hotel room? Want to make sure I understand that. I
Yeah.
maybe missed that before.
Basically, he's a wanted person. I'm basically observing the person. As long as I observe the person, I can grab the person, put him in custody, and take him custody to the magistrate.
But when you opened that hotel door, you didn't know he was there, so you didn't know he was a wanted person.
What-
You saw a vehicle in the parking lot that was connected with him. You saw a white car
Okay.
that was connected with him. How did you know what door to go to?
Like I explained earlier, sir, basically I went there for the other call. When I got there, made contact with the occupants of the vehicle, they told me, my brother is in room 125. I knock on the room. He opened the door first. Your
Okay.
customer opened the door first. Make contact with me, say, I don't know those people, and he closed the door.
So that's what led you to the door.
Yes,
But at that point, you had no proof when you made entry that he had done anything illegal or was doing anything illegal, other than the fact that he had a warrant.
I did not make entry. I didn't know he had a warrant at that point.
So you didn't even know he had a warrant when you pushed in the door.
Sir, I didn't know make entry at that time. I went back to my vehicle, verified his license plate, grabbed his name from the license plate, and verifying the system. With that, I was able to see his mugshot. I was able to see he have an active warrant.
So it was
That's-
at that point that you went back. You didn't take him into
Exactly.
custody until you verified.
Until I verified that he had a warrant. Yes,
And it was, he had a warrant, no other bad acts that day got him arrested. It was simply, he had a warrant and somebody
Exactly.
wanted to talk to him.
he had the warrant. And then when I was doing the investigation, I found out that he was.
Okay, just simply wanted to answer the question. He got taken downtown primarily because he had a warrant
Yes, sir.
and somebody wanted to talk to him, either yes or no.
Yes.
That's the witness.
What does it mean when someone has a warrant?
I'm sorry.
What does it mean when someone has a warrant?
Basically, that person is being wanted by the court to go and speak to the judge or go and speak with the magistrate about the charge. Then that person basically has to go through the whole process, through a court process. It doesn't mean that person is guilty of the charge. It just means that the person has to go over there and speak with the magistrate and go through the whole court process.
And what is your role? If you see that someone has a warrant, what are you?
My duty and my obligation per state requirement and the department requirement is to arrest the person and bring it to the magistrate.
Any voice in the matter?
No, ma'am.
And so that's what you did in this.
Yes, ma'am.
The jacket that he had, did Mr. Morganfield have the jacket on when you first came into contact with him?
He didn't have the jacket on. The jacket, I believe, it was in the vehicle, and the jacket was confiscated as evidence.
Why was it confiscated?
Basically, because it was the same jacket that was worn by the Mr. Morganfield during that incident that they labeled as a robbery a couple days before. So it basically was evidence of that incident.
And when something is evidence, where does it go?
It goes to the property room until the detectives release it.
And is that why you did not give him the jacket back?
Exactly.
And that's normal procedure for any type of evidence?
Yes, ma'am.
In the video, we saw Mr. Morganfield's hands. Do you remember where they were placed?
His pants, you say?
His hand?
His hands. Yes, his hands were behind him in handcuff, but like I said, I put double handcuff and he was just moving his arm to the front, moving it to the other side. So he was free, basically, other than having handcuff, but he was free, moving around freely in the back of the patrol car.
And you actually saw that occurring.
Yes.
Do you remember when he made a statement to you? I'm going to make sure every night you think of me.
Yes.
And do you remember when he said, I wonder where your bitch ass stay in San Antonio?
Yes.
Do you remember when he said, no Wendy's, and this is his language, nigga, catch you boy off duty, your ass is done with, your ass is toast, fucking meat nigga.
Yes, ma'am.
And defense talked to you a little bit about the room, the hotel room.
Mhm.
Can you describe what this hotel room was known for?
So this place have
Your Honor, objection, relevance.
Sustained.
Can you describe if there were any other males in the room? with Mr. Morganfield?
Yes,
How many?
I believe just one more. Yes,
So it's Mr. Morganfield and one other male
yes, ma'am.
and then two other females.
Yes.
I pass the witness.
Officer Hernandez, I'm gonna go out on a limb here and I'm gonna just ask, have you ever had to sit for 4 hours in the back of a police car handcuffed? Have you ever had to do that?
No, sir.
Could you imagine what it would be like after the first hour, the second hour, the third hour, over 4 hours? Can you even imagine what that would be like?
No, sir.
No further questions.
I have no further questions.
All right, is this witness excused or subject for recall?
Excuse from the state.
Defense? Is this witness excused?
Subject to recall, Your Honor.
All right, the rule has been invoked. What that means is you can't discuss your testimony with anyone. You can only discuss your testimony with attorneys for the state and attorneys for the defense. Just make sure you're available for recall if needed.
Yes, ma'am.
All right, thanks.
Thank you.
State, call your next witness. All right, state.
Ms. Barta, I'm assuming you're the same Ms. Barta who testified earlier in the guilt innocence portion of this trial, right?
I am, that's correct.
So again, can you remind the jury how you're employed?
I'm employed with Bear County Pretrial Services.
And prior to being with their county pretrial services, do you have any other relevant experience?
I do. I was a parole officer for the state of Texas for 2 years as well.
And there's a big difference between, I would say, parole and pretrial services. Is that fair?
Definitely, especially in the EM GPS division. Yes,
And EM, GPS, those are abbreviations.
yes. Electronic monitoring or global positioning system.
And since we're talking about it, what is that?
So it's an electronic monitor that an individual will wear for the time either they're on bond or they're on parole. And then it's usually either, well, for pretrial services, it's up to the court to modify or remove that condition.
So, again, you were one of Mr. Morganfield's pretrial supervision officers.
Correct.
In what dates approximately?
From October 2021 to February 2022.
So is it fair to say about 4 months?
Yes, yes, sir.
While he was on pretrial supervision, how many cases did you monitor him for?
Objection. The fact that a case has been filed is not evidence of guilt. However, it is possibly prejudicial and it is going to unfairly prejudice against a client.
All right, could I have parties approach?
Did Mr. Morganfield have conditions for pretrial services?
I'm sorry, could you repeat that?
Did he have conditions of bond?
Yes, yes, sir.
And those conditions of bond for his case, what did they include?
They included weekly reporting, that I'm sure of. The GPS full house arrest that was eventually modified over like the course of his supervision. The other one specifically I can't speak to, but a defendant can have random drug testing, weekly drug testing, all that kind of stuff.
So as far as Mr. Morganfield is concerned, how would you consider him in compliance with pretrial services and his conditions of bond?
His compliance, when I first took over his caseload, which was just when an officer left and I was the officer that got her caseload. He was in compliance. He did check in weekly. He would just call and he would check in that way. And then There was a time when he was granted work and he wanted to actually start working. That caused a lot more problems in the compliance. He was granted a schedule to work and then he was working through a temp agency. So within my experience and questions with this specific temp agency, he would report to the temp agency to go to work. They would send you out on a job or give you a ticket or an address. You would go to that address and then you would come back to the temp agency, which is called pay setters. And they would pay you for the day. When Mr. Morganfield started doing that, he was not, or started reporting to pay setters. He wasn't reporting to pay setters. He was driving all over town. He was driving to 8 gas stations in a day, North Star Mall, North Park Mall, Academy on Pear and Vital, and then he'd go to a Circle K off 151. And so these are unapproved locations the defendant is not supposed to go to unless you have prior approval. That also being said, rule number 4 of the GPS contract that everyone signs, if a GPS is placed on their leg, states that you are allowed to work with approval, with prior approval. We want them to work, we want them to succeed, we don't want them to fail. So when he was traveling to all these unapproved locations, I did staff it with my supervisor. I said,
Your Honor, objection, she's non-responsive, she's just rattling off.
All right, that'll be sustained.
I'll ask you some questions in between.
that's okay.
So when he was supposed to just be going to work and back, it's fair to say you were having some problems with that.
He was absolutely not going to work at all.
And as it relates to him going to these other places, you said you notified your supervisor?
Yes, so when a defendant travels to an unapproved location, if it's during the day when we are monitoring them, we have a certain amount of time to address why they're going somewhere, where they're going. If they don't have an excuse or a reason, then a warrant can be requested at that time, whether it's while I'm on the clock or after hours.
Okay, and what is the purpose of staffing it with a supervisor?
They're the ones who make the ultimate decision if a violation is accepted.
Did you communicate these issues with Mr. Morganfield?
Yes, most definitely.
And what was his general response to you bringing this up to him?
His initial response most of the time when we interacted for something where he was breaking the rules was anger, or he would get very upset with me. I would try and explain just word for word. I really just spell out the GPS contract. This is what it says, and this is what you're doing. And that's not within compliance.
And in your conversations with him, did he give you any indication that he was going to go back into compliance?
No, not in this specific instance, no.
Okay. And did you have any other issues with him as it relates to his pretrial conditions?
So he was rearrested in the same instance that I was speaking about earlier, which is what I was getting to, is that all of these unapproved locations, after I submitted a violation, that was denied by my supervisor because Mr. Morganfield came into the office and made a big upset to 2 of my supervisors who did take Mr. Morganfield word over myself.
Objection, Your Honor, relevance and non-responsive.
Sustained.
So ultimately, was he violated?
He was not violated. He was rearrested on a new charge.
And is that when he was, he moved to a different pretrial supervision officer?
That is correct. Mhm.
Your interactions with Mr. Morganfield, as it relates to pretrial supervision, I should take a step back. Are you familiar generally what probation is?
Yes, sir.
In comparison to pretrial services versus probation, generally speaking, are there more conditions of probation than pretrial services?
I would say so. Yes, sir.
And in your 4 months with Mr. Morganfield as his pretrial supervision officer, was he always compliant?
No.
And what was his general, should I phrase it? Was he a pleasant person to interact with?
Objection.
All right, that'll be overruled.
You can answer that question.
Could you repeat it?
Was he always a pleasant person to interact with?
Not always. No.
Did he ever use foul language towards you or any other pretrial supervision pretrial supervision officers that you are aware of?
I wouldn't call it foul language to myself. He just got very heated and very upset. I don't recall him specifically calling me a name or something like that, like nastiness like that. No, he just became very upset and I was just unable to talk to him.
Did he ever indicate to you that basically complying with these rules of pretrial services were beneath him?
Somewhat, yes. I mean, it just kind of seemed like the rules didn't apply, or if he read something that he believed it read a certain way and it didn't, and I would try to explain, it just wouldn't really matter. He didn't want to hear it.
So if you had to categorize if he was compliant versus non-compliant with his conditions in those 4 months, which would you say?
I would say not compliant for the last 2 months, definitely.
And those last few months are when he was switched from full house arrest to partial.
That's correct. Or his conditions were changed. I don't know if it was that specific change. I believe there were some different details, but yes, sir.
I'll pass the witness charge.
Defense.
Ms. Barta, my client never threatened you at all, ever, did he?
Not that I recall, no, sir.
Well, he didn't. Not that you recall, I asked you a very specific question. He never threatened you, did he?
I said a very specific answer. Not that I recall, no, sir.
Because if he did, you would definitely reported that to your superiors and probably informed the court, right?
Probably so, yes, sir.
So it's fair to say you and he just didn't get along very well, right?
I wouldn't say that at all. We got along very well for the first 2 months. We,
Okay, so
Spoke to him every
the
week.
last 3 months, you two didn't get along very well.
no, sir, when he was not in compliance.
All right, but while on pretrial supervision, he was never revoked for that period of time until the very end, right?
Correct.
And if I recall from your testimony, he was revoked because of something you said, right?
No, sir.
Didn't you testify that my client made a comment that I don't understand why I'm being charged or why I'm guilty of something like this when somebody consented? Remember that comment?
Yes, sir.
Well, that's what got him revoked, isn't it?
Revoked when, sir?
Huh?
Revoked when?
Well, when you informed the court about that and the state. Right?
No, I'm not understanding the question.
Well-
He wasn't revoked off my caseload in the first place. He was rearrested on a new charge, so he was taken off my caseload.
Okay. So, but you did say that, right? You did inform the court, I mean, the state about that comment, right?
Yes, sir.
And that's the comment that you have as an officer of the court didn't preserve.
I'm sorry?
Where is that recording?
It's not a recording. It was a text message sent to me from
Where's the text
Mr.
message?
Morganfield. In an older, I wasn't asked to supply the text message, sir.
Did it exist?
Yes, sir.
I mean, you could have brought it to court,
No, sir.
so it doesn't exist.
The text message was on our older work phones that are erased. Yes, sir.
And so why didn't you preserve that if it was so important?
I never said that it was important. It was just notated as that is something that he was said to me
How
that
did
I
you
did
let-
not
How
forget.
did you let the state know about that 10 days or 15 days or whatever it was before this trial was to begin?
I'm sorry?
How did you let the state know about that 10 days before, 10 days or so, whatever it was before the trial started?
His current officer and I were speaking about our experiences with Mr. Morganfield.
Oh, so you guys talked with each other about Mr. Morganfield?
My other officers, we talk about our defendants. Yes, sir.
But he wasn't your defendant any longer.
That's correct.
And so you just tried to figure out a way to conveniently screw him over.
No, sir, I
That's
wouldn't say
exactly what
so.
you did. I mean, you're not his
Is
friend.
there a question?
Yes. You're
What
not
is
his
the
friend,
question?
right?
I'm
You're
not any of my defendants' friend,
Right.
no, sir. That's my job.
So, no, it's not your job. Your job is not to convict somebody or try to convict somebody. Your job is just to make sure that they do what they're supposed to do to go to court and nothing else.
Correct, which is
But you
what I've
went
done.
way beyond that.
In what sense? Am I being questioned?
You are.
Is there a
You're being
question?
cross-examined by me. Because I'm not your friend either.
Judge, I'm gonna object to this point. This whole segment has been argumentative.
Not gonna be overruled. Ask your question.
So you conveniently found evidence and gave it to the state 10 days before trial that you can't even prove that it exists other than your own testimony. Isn't that right?
I didn't conveniently
Isn't that
find
right, ma'am?
information.
Answer the question.
I am. I
It's a
did not
yes or no.
conveniently
Does
find
it exist?
information.
Can you find it?
Can I physically hand it to you? No,
Yes.
sir.
It doesn't exist. Right? You don't know where it is.
I know where it is. I can't physically hand it to you.
Pass the witness.
Ms. Barta, let's talk about, since he wants to talk about how we came into contact. Did you ever reach out to me?
No, I did not.
Okay, I reached out to you, right?
That's correct.
And that is after Jasmine Lear came to this courtroom, right?
That is correct.
And did you ever communicate this, this statement, to me directly? Meaning, did you come to me to provide that statement to me?
No, I didn't seek out anyone to give this information.
Because the fact is, I reached out to you, right?
That's correct.
After Jasmine Lanier came to this courtroom to potentially testify in a pretrial matter.
That's correct.
Let's talk about the actual statement itself. You said that was through a text message,
Yes, sir.
and you said that you had an old phone system.
No, we just had old cell phones, so we got updated cell phones.
In pretrial services, is it your job to document necessarily inculpatory statements?
I'm sorry, I don't know what that word means.
Inculpatory should, an admission,
Okay.
something that hurts him penologically or punishment wise. Is it your job to document those statements?
No, it's not pertaining to guilt or innocence. No.
So is it fair to say that if he would have, when he made this admission to you, that's not something you would reach out to the state to tell him?
No,
But if we ask you and we subpoena you to testify, you do that, right?
that's correct.
Because you follow the law.
I think so.
Mr. Cantrell talked about this statement by Mr. Morganfield. I had a lot of questions about it. What was the statement that he told you? Mr. Morganfield told you?
So in this instance, it was a lot of messages that were sent to myself. It was just rambling, like 2 or 3
Objection.
messages.
It's a very specific question. Answer the question.
All right.
Is that a legal objection?
Yes, it is.
What is your legal objection?
My legal objection is that it's non-responsive.
Sustained.
What is the specific statement that he gave to you about, that was related to, his case or cases?
He said, I don't know how it's even assault when they're the ones that go down on me. He also didn't understand how he didn't have clout in the situation because he's the rapper and they were nobody.
Objection, again, non-responsive.
Sustained.
Is that same statement, the clout statement that we talked about during guilt and innocence?
Yes, sir.
Okay. And is that kind of consistent with his demeanor and interactions with you?
Correct, for most
Objection,
situations.
Your Honor, that's speculation. She doesn't know anything about him being a rapper or otherwise.
Sustained.
Did he tell you he was a rapper?
Yes, sir.
So you took him at face value?
Yes, sir.
No reason to believe that he wasn't a rapper, right?
I don't have any, no, sir.
But prior to knowing him, you didn't know that he was a rapper.
No, sir.
I'll pass witness.
Ma'am, have you ever listened to any of his music?
I have not.
All right, so you said, and you testified to the state that it's not your job to document either exculpatory or inculpatory information, right?
It's not my job to document guilt or innocence information, no, sir.
That's exactly what you did. If it wasn't your job, but that's what you did conveniently 10 days before this trial was to start. And there's no documentation of it that's preserved anywhere. Isn't that right?
I was asked by the court to come here. Yes, sir. I didn't seek out to
And I
divulge
believe you
information.
testified that when he made the comment about somebody going down on me, if it was consensual or voluntarily, he didn't say in any way that it was about this case, did he?
He did not.
You don't know what context that was in.
I don't know, sir.
Thank you very much, ma'am.
State,
Just 1 second, Judge. Did you actually document that guilt innocence statements that we're talking about?
That statement itself is not documented, no, sir.
So are you testifying based from your memory?
That is correct.
I'll pass witness.
Your Honor, there's a term called res ipsa loquitur in law. And it just basically, her testimony speaks for itself.
I don't object to the sidebar.
is there a question difference?
No other questions, Your Honor.
All right, is this witness excused or subject for recall?
The state asked that she be excused.
We'll agree to that.
All right, you're excused. The rule has been invoked. You can't discuss your testimony with anyone except for attorneys for the state or the defense. State, call your next witness. All right, you're still under oath. State,
Thank you, Your Honor. Sarah, you're aware that this jury has found Alexis Morganfield guilty of sexual assault with a child, right?
Yes,
As far as post March 29th, 2020, how was what has happened to you affected you?
it's affected my everyday life. It's affected my mental health, took a toll on my mental health. I developed major anxiety after the incident.
Okay, so let's break this down a little bit. You said that it has affected you every day.
Yes.
How so? Specifically.
For example, I used to get like only A's and B's in school, and then after the incident, end of junior year, I was failing most of my classes. It was hard for me to keep up with my schoolwork.
Okay, and then you said that it's affected your mental health. Is that fair?
Yes.
How so?
It's given me a lot of anxiety. I currently take prescriptive anti-anxiety medication.
Were you on those medications prior to March 29th of 2020?
No.
And there was a third thing that you said of how it's affected you. Do you recall the third way that's affected you?
That I just said right now.
Yeah.
Um,
It's affected you every day,
Oh.
affected your mental health, and there was something else.
Oh, it's it's affected the way I connect with people.
How so?
Being able to trust people, I'm weary of it. And like,
all right, excuse me. Sorry to interrupt, but I've received the break sign from the jury.
Okay.
So we're gonna break. And is it okay if I bring you all back at 4? Is that? All right, State.
Thank you, Your Honor. Sarah, have you dated since this happened?
no,
Okay. Is there a reason why not?
not necessarily.
Do you imagine dating is going to be different for you in the future?
Yes.
Why so?
It's been difficult for me to display physical affection with others, not just like with men, but just with like friends and family in general.
Has this affected your relationship with any of your family members?
Yes, I know for.
Who?
I would say like my siblings and my parents. I was very closed off for a while and really depressed, and I didn't really speak to them about the situation too much.
Have you talked to your mom about this, about the case, rather?
Yes, but wasn't able to open up to her right away.
Have you been able to open up to her since that day?
Yes.
Has this affected your relationship with friends in any way?
Yes, I would say so.
How so?
Just trusting new people, and the same thing with physical affection.
And then you briefly mentioned that after, or just after this, when you were still in high school, it affected your grades. Does it continue to affect your grades?
No, not anymore, no.
Have you had to go to any counseling or therapy for this?
I know I went to a therapist, but I don't remember if it was prior or after the incident. But I did see a therapist for a while.
Can you think of any other way that this case has affected any of your relationships with people?
I would say just like opening up and being vulnerable in general with people. I'm like much more socially anxious.
And can you think of any other way that this is affected, not just relationships, but you?
It's affecting my mental health, and it was affecting my like ability to focus on myself and my needs, and I was very unmotivated for a long time. So there was like basic tasks that I couldn't complete.
Are you still working through some of those things today?
Yes.
Do you imagine that you'll be working on some of those things in the future?
Yes.
I'll pass witness at this time.
All right, defense.
Good afternoon, Sarah.
Good afternoon.
I'm glad you're getting better and making good grades and moving on with your life. I'm sure none of this has been very easy for you. I'm sure you'll agree with me, isn't it true that when people make choices in their lives, they're pretty much controlled. They pretty much control their own destiny, right?
Not all the time, no.
Well, for example, when you go into a car with 3 strangers trying to meet someone you've never known before, that's probably a bad choice, wouldn't it? Wouldn't you agree?
Yes, I agree. I could have made better decisions, but I don't think that gives anyone a right to violate me.
Well, let's go over the testimony again. My understanding is that you testified that you, whoever you gave oral sex to, did not, no one forced you to do that. You did that consensually. Isn't that right?
I could have chosen better words.
You chose to give oral sex to whomever that was in that car, didn't you? That's what you testified to.
That is what I testified.
Yet there was no evidence of any DNA or otherwise. No marks, no bruises, no scratches. Isn't that right?
Correct.
You also lied about posting inflammatory social media content regarding the defendant here. Isn't that right?
I said I didn't remember.
Well, actually, you said that you might have. But you specifically answered to the state when they asked you about that. You said you did it after you had contacted and spoken to my client.
Yes, that's true.
But there's no way that could be true. Because he could not talk to you and ask you, please don't post those things unless you had done that beforehand. So that was a lie, wasn't it?
I meant it was after I had a phone call with him, not after the text messages.
But
That's
you
what
had
I said.
already been putting that content on, hadn't you?
After I had the voice call with him.
But that can't be true, ma'am, because he talked to you, begging you to please take that off. So you had to have done that beforehand.
Before the messages, yes.
And it's convenient that you would testify in one way to answer the state's questions and then answer a different way when the state would the defense would ask you questions. You would basically change your story.
Judge, I'm gonna object to argumentative.
Overrule.
You did that multiple times, didn't you?
No, I don't think so.
Did you know how old my client was?
No,
Did he know how old you were?
I don't know.
Did you tell him you were 16?
I don't think so. I'm not sure.
Other than your own testimony, do you realize there's no other testimony whatsoever, evidence to link my client to you other than the conversations regarding the social media afterwards? Do you realize that?
Can you repeat that, please?
Sure. Other than your own testimony, there is no evidence to link my client to you or being there other than your own testimony.
Correct.
They couldn't find the DNA. They couldn't find the gray Charger. They couldn't find Brandon. They couldn't find the store clerk. They couldn't find the video of the store. You didn't want to report this, but your sister did. There's no DNA that links him to you. There's nothing other than when my client sees that you're posting things on the internet, he's asking you to stop doing that. Isn't that true? That's the whole case here, isn't it?
I'm gonna object to compound question.
Compound question will be sustained.
So your testimony is the only testimony to show that he was even there in that car with you. Isn't that right?
Yes.
There is no other testimony or evidence to show that he was present there with you. Isn't that right?
Yes.
There is no evidence that he owns a gray Dodge Charger that you know of. Isn't that right?
Yes.
There's no evidence of any DNA, even though you claim you performed oral sex on him. There's no evidence of that from DNA or any other bodily fluid. Isn't that right?
Yes.
There was no bruises. There was no scratches. There was no other physical evidence whatsoever that he harmed you in any other way. Isn't that right?
Object to acid answer.
Overruled.
You can answer, ma'am.
Correct.
You claim that he did not force you in any way to perform oral sex on him. Isn't that right?
Yes, he didn't physically force me.
There is no cell phone or text or anything regarding what you claimed that night, calling Brandon or otherwise. Isn't that right?
Can you repeat the question?
Yes, you had claimed that you had called Brandon or somebody had called Brandon using a phone or somebody's phone. There's no evidence of that either. Isn't that right?
I wasn't aware of that.
Brandon, as far as we know, doesn't exist. Isn't that right? In this courtroom with respect to evidence.
Correct.
The store clerk who the store that you allegedly went to, there's no evidence of his testimony either. Isn't that right?
I was told the detective never went to the gas station to,
And so we have no evidence of that, right?
right, yes.
The other person in the store, the customer who let you borrow a phone, he did not appear before this court. Isn't that right?
Judge, I'm gonna object. This violates the rule, lack of foundation. The rule is invoked, and so she couldn't possibly even testify.
I thought it'd be sustained.
You didn't even want to report this, and you had at least 2 different opportunities. Isn't that right?
Yeah, I was still processing everything, so no, I didn't want to report it right away, no.
And you lied to the jury when you stated that it was he who contacted you and talked about getting that stuff off the internet, but you had already put that on the internet first. Isn't
He
that right?
was calling me, and then we had a FaceTime call. That's what I was thinking of. I posted after that call, and that's when he reached out to me again a second time.
But he reached out to you, and this is my client. The one thing we can say for sure, he reached out to you because you had been posting things about that, and he asked you to stop doing it, and he told you, this is not me. Isn't that right?
Yes,
And you testified earlier that you've been getting major anxiety. You were having mental health problems, can't trust people. It affected you and your relationships and friends. And that you had never been on any kind of prescription medication regarding mental health until after this. Isn't that right?
I said anxiety, no anxiety medication until after this.
But you had been on Prozac before this, hadn't you?
That was for depression.
Prozac, but it was a mental health, and it helps you with your anxiety too, doesn't it?
I wasn't dealing with anxiety
Or
before
were you
then.
just trying to mislead the jury when you failed to say that you were taking Prozac before this time?
I was specifying my anti-anxiety medication. I didn't think I had to specify any other medications.
You were taking Prozac before this ever happened. Isn't that right?
I didn't know that was an anti-anxiety medication. It was used to treat my depression.
That's the witness.
State,
May I approach, Judge?
yes.
The witness. The witness, sorry. Sarah, you understand that Alexis Morganfield has been convicted, right?
Yes,
So a lot of those things that Mr. Cantrell talked to you about, he must not understand that he was convicted either. So you understand that he was convicted of on or about March 29th of 2020. Alexis Morganfield, hereinafter referred to as defendant, did intentionally and knowingly cause the penetration of the mouth of Sarah Funadoriano, a child who was younger than 17 years of age and not responsive to the defendant with the defendant's sexual organ. You understand that's what he has been convicted of at this point.
yes,
Okay, so all those questions that Mr. Cantrell asked you, those relate to whether it happened or not, right?
yes,
So you understand at least that the jury has already made a decision that he is guilty of this offense.
yes,
And Mr. Cantrell used a lot of words that alluding to assuming this is the person or assuming this is and pointing to Mr. Morganfield. You know that's Alexis Morganfield, right?
yes,
As far as your records are concerned, I'm going to show you what's already been admitted as State's Exhibit number 7. Which is, have you ever seen your state exam?
no,
Okay. So you would agree with me that this is you, Sarah Funadoriano,
yes,
and in that, under section 1, where it lists medications, Prozac,
yes,
right?
yes,
Okay, so this is already an evidence entering the guilt innocence. So when Mr. Cantrell says that it's taken for, that you didn't mention that, that's already an evidence. Right.
yes, yes,
As far as you're aware, is Mr. Cantrell a medical doctor?
no,
So, to your understanding, when you were prescribed Prozac, what was the purpose of being
to,
prescribed Prozac?
to treat my depression,
Okay, so it wasn't being given to you to treat for anxiety.
no,
Do you remember during innocence, we showed you the video of that you took your conversation with Alexis Morganfield?
yes,
And in that recorded conversation, does Mr. Morganfield ever say anything about posting things online?
no,
Did he say anything during that conversation about posting anything online?
no,
Was it before or after that recorded phone call that you started posting stuff online?
after.
And what things were you posting?
I was posting defamatory things, calling him out, calling him a rapist, and saying that he sexually assaulted me.
When Mr. Cantrell asked you a lot of questions, and I hate to go back over all this stuff from guilt and innocence, but I wanted to touch on some of it. He asked you a lot of questions about, well, there's no evidence of these things. So let's just go over a couple of them to see if that's true. When he said that there's no evidence that Brandon exists. Well, I should say, any of these questions that he asked you about whether there was any evidence of it, you were under the rule, right? We talked about this, right?
Yes,
That you couldn't listen to other people's testimony,
yes,
and you didn't.
yes.
And so you can't possibly know what testified to.
No, I could not know.
Would it surprise you to know that your mom testified that she knew who Brandon was?
I didn't know, no, or that she testified about him.
Does your mom know Brandon?
Yes,
Has she met Brandon before?
yes,
So if she testified that Brandon was a person, there's other evidence of that, right?
Yes,
When he says that there's no other evidence besides your testimony to link you to Alexis Morganfield, you provided that copy of that recording, which was Marcus State's exhibit number 5. You provided that to this court, right? Or to the DA's office.
yes,
And you reviewed it prior to testifying.
yes.
And do you remember why you called Alexis Morganfield?
To ask him why he was spamming Brandon Johnson's phone.
Okay. And in State's exhibit number 5, do you make a statement at the beginning of that call to that effect?
Yes,
So again, that linked Mr. Morganfield to this, right?
yes,
During that phone call, did he ever deny doing anything to you?
no,
Was it not until after he started posting online that he was a rapist, that when he reached out to you and denied?
yes,
I'll pass the witness.
So
Defense.
this will be brief. But you actually were reporting false things about my client on the internet, weren't you?
no,
He did not rape you. He didn't sexually assault you. You testified in this courtroom multiple times that what you did to whomever that was, that you did it voluntarily and it wasn't, no one used force. Isn't that right?
I think we have different definitions on what sexual assault is. I think he did sexually assault me.
Did he forcibly have
Coercion, he coerced
Excuse
me.
me, ma'am. Did he forcibly have sex with you in your vagina?
No,
So the only sex we're talking about is you giving someone oral sex. Is that right?
yes,
And you were very specific because I asked you multiple ways, did anyone force you to have sex? Did you do it willingly? And you said yes, didn't you?
yes,
So when you were posting things about him, saying that he was a rapist, that wasn't true. Isn't that correct?
correct.
And when you said he sexually assaulted you, that wasn't true. Isn't that correct?
No,
You claim that he's spamming Brandon's phone. How do you know that?
because Brandon sent me a screenshot of missed calls from him.
Okay, so you're saying somebody was spamming.
It was the
Brandon's phone.
same phone number, and when we called the phone number, it was him.
You realize that people can use different numbers to do things like that, right?
Yes,
And that there's different apps for that kind of stuff, right?
yes,
So you don't know for a fact that it was him. It could have been someone else.
when
Isn't
I
that
called
right?
the number, it was his face on.
Understood. People can have a phone and someone else can use their phone, and when you go back and check to see who it is and you call that number, it could be belonging to that person. They don't even know they're being spammed. Do you realize that?
Yes,
So Brandon never told you that Alexis Morganfield was spamming you. It was just a phone number that may have belonged to him. Is that right?
I believe it might have been the same phone number that I texted Brandon on, but I don't remember. That also could have been it.
Sarah, thank you very much. I know this is difficult and I'm sorry my questions were difficult. That's the witness.
I have no further questions, sir.
All right, is this witness excused or a subject for recall?
We ask that she be excused.
She can be excused, Judge.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone except for attorneys for the state and the defense. Do you understand?
Yes.
All right, thank you. State, call your next witness.
At this time, the state rests.
All right,
Do we have like a 5-minute recess? But
yes.
I think we're gonna put some testimony on.
All right, defense.
Ms. Humphrey. Do you know the gentleman sitting 2 chairs to my right?
Yes, my son,
He's your son. What is his name?
Alexis Morganfield Jr.
Junior. Okay. And how old is he?
Right now, he's 22.
Okay. Did he grow up in your home?
Yes, sir.
Okay. Has he lived with you in recent times?
Yes, sir.
Have you been an active part of his life?
Yes, sir.
If he had ever been convicted of a felony anywhere before this, would you know?
Yes, sir.
Before this week, has he ever been convicted of a felony?
No, sir.
How old would he have been on March 29th, 2020?
He was 19.
Pass the witness.
Ms. Humphrey, you're Alexis Morganfield's mom, if I understand correct.
Yes, sir.
And you've been in communication with your son since March 29th of 2020 up until at least yesterday, correct?
Yes, sir. Even though I've traveled, I'm a nurse.
And you spoke with him about this case, correct?
Yes, sir.
Even as recent as yesterday, you spoke with him about this case.
Not yesterday because he's very distraught right now.
Okay. So after the verdict on Friday, you talked to him, right?
Yes.
And then you talked to him at least twice on Saturday, right?
Your Honor, we're going to object. It's this
Oh.
direct.
It's about
That'll
two
be
or three
overruled.
times. Yes.
I'm sorry, I didn't hear you.
Yes, we talked. Yes, sir.
And then you talked on Sunday as well.
No, not Sunday.
Okay. So after this verdict, so your communications, your phone calls with your son, you understand they're recorded, right? When you have
Yes,
phone
sir.
calls?
Yes, sir. I do.
And is there that warning at the beginning of the phone call is being recorded, right? You understand that?
Wait, say that again. I'm sorry.
You understand that when y'all have phone calls, you're aware that that the conversation is being recorded,
Yes, sir.
right? So when he calls you.
Yes, sir.
And during those phone calls, you have discussed this case, correct?
I don't remember discussing the case.
Okay. Do you remember him making statements that the jurors were paid?
No, I don't remember that. No, sir.
Do you remember him making statements that, and you agreeing with that basically the state railroaded him?
No, sir.
And do you remember making statements that if they were professional trained jurors on this, that's why they convicted him?
I don't remember saying that.
Okay, because y'all discussed a lot of things on the phone call. Y'all discussed things about motions you're gonna file. Do you remember that?
No, I do remember about some motions. Yes, sir.
Right, because you're taking notes on your computer as you're talking, right?
I don't remember about a computer.
Okay, so he's telling you about motions that he wants filed and you specifically say in those phone calls. Oh, hold on, I'm writing them down. You remember that?
You probably talking about someone else
Okay,
because I'm not the only one he talks to.
but not motions about for habeas corpus?
I do remember that.
Okay, 'cause I mean, I can play those phone calls for you if you really don't remember, but I think.
I do remember that one.
Okay. Because at the very beginning of those phone calls, obviously he doesn't agree with the verdict that this jury has reached. That's fair to say,
That's fair to say.
right? And in that, he is questioning these jurors about whether they're paid, whether they're professionally trained and things like that, right?
No, I can't comment on that because I'm not, I
Hearsay.
can't make a statement like that. I'm sorry.
Objection to hearsay will be overruled. Is there any other objection?
And in those phone calls, You remember him also alluding to the fact that somebody must have went back there and told the jury just to convict him of something?
I don't remember that, no, sir.
Is it that conversation didn't happen, or you just don't remember?
I don't remember that about someone told him to do what you're saying. I'm sorry.
You were present for most of the guilt innocence portion of trial, right?
Yes, sir.
Okay, so you got to hear the testimony, those witnesses,
Yes, sir.
and you understand that this jury of 12 people, that both the defense and the state went through voir dire with, convicted of a sexual assault of a child.
Yes, sir.
And you're not here to tell this jury that it didn't happen or anything like that, right?
No, I'm not up here to say.
All you're here is to tell this jury is that he's never been previously convicted of a felony.
That is correct.
You were also, you talked to Alexis Morganfield today, right?
No, I haven't had any conversation with him today.
You don't recall speaking with him to calm him down?
Oh, about that. Yes, sir. Because he's not understanding any of
Objection, Your
this.
Honor, that was not.
He's not understanding
Not
any
in
of,
evidence.
everything that's going on. So
Will be
he's,
sustained.
But you talked to him today
yes,
and you had to calm him down.
Again, assumes facts not in evidence, Your Honor.
Can I have parties approach?
Moving on from today, just generally speaking, when Alexis hears something or something happens that he doesn't like, usually how does he react?
he likes to talk with me about it, me or either his father, and asks us our opinions, things of that nature, as such as this. He did advise us that, Mom, I just don't know what to do. I'm a Black man, have to come up before the system. And, he said, I just may not stand a chance, Mom, and I don't even know who this person is.
Okay, so he's maintained, even despite this jury convicting him, that he doesn't even know Sarah.
That is correct. He does not know who this person is.
How about this, Judge?
Defense.
No further questions.
All right, you may step down. All right, defense, call your next witness.
Defense rests.
State, do you close?
Take rest of the-
Defense, do you close?
Defense closes.
All right, ladies and gentlemen of the jury, you've heard all the testimony that you're going to hear in this phase of trial. I'm going to read to you what is entitled Charge of the Court on Punishment. Members of the jury, by your verdict returned in this case, you have found the defendant, Alexis Morganfield, guilty of the offense of sexual assault of a child as alleged in count 1 of the indictment. It is necessary that the jury assess the punishment for this offense. You are instructed that the punishment for the offense of sexual assault of a child as charged in the indictment is confinement in the Texas Department of Criminal Justice Institutional Division for any term of not less than 2 years or more than 20 years. In addition to imprisonment, an individual found guilty of the offense of sexual assault of a child may be punished by a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. The defendant has applied on written sworn motion for community supervision, stating among other things that he has never been convicted of a felony in this or any other state. Our statutes provide that where a defendant is found guilty of the offense of sexual assault of a child as they are charged in this indictment, and the jury assesses the punishment at not more than 10 years, and they further find that the defendant has never been convicted of a felony in this or any other state, the jury may, within its discretion, recommend community supervision during the good behavior of the defendant. If the jury does recommend community supervision, it will be granted by the court. If there is any evidence before you that the defendant may have committed any act of misconduct other than the offense of which you have convicted him, you are instructed that you may use that evidence, if any, in assessing punishment in this case, but only if you find from the evidence beyond a reasonable doubt that the defendant committed such act of misconduct, if any. In the event you have a reasonable doubt as to whether any other act of misconduct was committed or as to whether the defendant was involved in such other act of misconduct, then you will wholly disregard the evidence, if any, which may relate to any such matter. You are instructed that the defendant may testify in his own behalf if he chooses to do so. But if he elects not to do so, that fact cannot be taken by you as a circumstance against him, nor prejudice in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, any system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is in prison may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if sentenced to a term of imprisonment, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. Suitable forms are attached hereto for your verdict, if you should care to use the same. However, such forms are not intended to influence you in any way in arriving at your verdict. In any event, your verdict must be unanimous in writing and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and verdict forms are attached. State.
We will reserve our time.
Defense.
May it please this honorable court. Sorry for that. Thank you, first of all, for paying close attention. This case, it wasn't easy. It took a lot longer than a lot of you probably expected. From the bottom of my heart and my client, my co-counsel in the state, and my client's family, thank you so much. We couldn't do this without you. We accept your verdict of guilty, but we don't agree with it. Okay, just like all of you all had a choice. We certainly respect it, and I know you guys worked really hard because you were in there, 2 days deliberating, so we know you were working hard. If you didn't like the way I cross-examined certain people, hold it against me. Don't hold it against my client. He has maintained from day one that he's innocent of this case. You've heard all the evidence. But here's something you haven't heard. The Romeo and Juliet law that says that there's an affirmative defense if you're 3 years different,
Judge, I'm gonna
16 to 13.
object to relevance.
It's relevant with respect to punishment as to they need to know what the law is and how short of a time that he missed that. So I think it's
Right, it'll
relevant.
be overruled.
So there's the Romeo and Juliet law that if you are 3 years age in difference, 16, if you normally think if you're 19 and you're 16, then it's an affirmative defense. Well, the way that law is written, we couldn't get it in the jury instruction. The court was right on how she ruled according to certain courts in our jurisdiction right now. So my client was 3 years, 2 months, and 7 days. In other words, 2 months and 7 days. If he was born 2 months and 7 days earlier, you would have had to, the court would have instructed you to find my client not guilty. So think about that. Is there really a difference between 2 months and 7 days? I submit to you, use your common sense, and it's no. So when a 16-year-old has a sex with a 19-year-old or a 17 with a 15-year-old, you would think they'd have that affirmative defense, but not if they're 1 day over 3 years, according to some legal scholars. One of these days that'll probably change or get more specific. So, I'm sure you saw my client and I literally talking the whole way through this trial because he never understood why he was here when somebody consented. And it's because he missed that by 2 months and 7 days. And he just didn't know, he couldn't understand it. I mean, think about it, he's 19. I have a 24-year-old son and he's 19. He was just smart kid. I mean, but he not as smart as girls that I knew. That girls are a whole lot smarter than guys. I'll tell you that right off the bat. They just are. So all I can say is that just look at the evidence. You found my client guilty, and I accept that. But what's the proper punishment? The proper punishment in this case is probation. You've heard he has no felony conviction, because if he did, the state of Texas would have brought it to you. They would have said, here he is, felony conviction. And on top of that, if he did, we couldn't even ask you for probation. So rest assured, he has no felony conviction. The other thing is that he is a black kid, and I'm not trying to make that an excuse. It's the facts. They're afraid, and they have a reason to be afraid. They have a saying about driving while black. Every black mother and father has talked to their kids about it. So, you get stopped, put your hand on the wheel or something to that effect. Make sure they know that you don't have a gun. But 9 times out of 10, a lot of those, just because they're black, they'll have a gun drawn, even in this city. And we've had black kids killed innocently just recently from stops. So it's not something that he's using as an excuse. It's a fact. It's just where we're at right now. And I think, and it's unfair to law enforcement. Because we have some great law enforcement, especially like the people here in this courtroom who are law enforcement. But what's appropriate when you have a girl say, you know, you would think someone would know better than get in a car with three different guys that are strangers to go meet someone you never met. That's just dangerous. She's got to take some responsibility for her actions. But for 2 months and 7 days, this judge would be ordering you right now. You have to give him probation. So think about that. This kid doesn't need to go to prison. If he's on probation, the probation department will watch him. I promise you, this judge will watch him. All right, put him on probation. You can do it up to 10 years if you feel it's necessary. But whatever length of time you decide is necessary, he will be watched. He will be monitored. He will be reporting. And they'll do things to help him. Anger management, for example. Educational classes. I'm sorry about the facts on this case. They're awful. But my client said he didn't do it. The evidence is scant, but we have to respect your decision. If you believed Sarah through all the different things that happened, but the one thing we know for sure on the count that you found him guilty of, on the sexual assault of a child, she told you it was consensual. And she did, mind you, remember twice going back in the car after the first time. So 2 months and 6 or 7 days. Do you really, is that much difference from an acquittal that you have to find him not guilty? But at that point, do you say he goes to prison? The logical thing is, at this point, please, ladies and gentlemen, I beg you, probation is appropriate. I've been doing this for 35 years, and this is an appropriate probation case. And thank you so much for your time. You guys just, you really fought hard in that jury room, and we're fortunate to have jurors like you. Thank you very much.
Thank you, Mr. Cantrell. My name is Ben Stevenson, and I have known Alex, as we affectionately call him. I've known Alex and his family for several years. I've known Alex for 4 years, going back to probably 2018. I've known his dad, who goes by Alexis, going even farther back, probably at least 10 years. His dad and I had many conversations about his dad. His dad's uncle was Muddy Water. I doubt if that means anything to any of you, but there is a strong family with a rich musical heritage. And here's a young man who is very gifted musically. We did not get to share with you the ways in which he is gifted musically, but I've heard some of his music. He's good. He's real good. And there are a lot of things that can come along when a young, popular music artist, rap artist, whatever, is on their way up. There are a lot of things that can come up and trip a person up. When I met Alex 4 years ago, he wasn't the most mature person I'd ever seen, even at 18. He had a lot of growing up to do. Why? Don't know, doesn't matter, but he had quite a bit of growing up to do. And his dad has had many conversations with him. When we heard his mom say that he goes to his parents when he needs information, he goes to his dad a lot. I've heard a lot of those conversations. He respects his dad a lot, and he's getting better. We're dealing with a case here that is roughly 2.5 years old. Sitting over at council table here is a 22-year-old. But we're talking about a time when he was 19 and change. Now, decisions that one makes very often do follow them. And the chickens come home to roost, and there are consequences for actions. We've heard a witness who is older and wiser say that things arising from this case have permanently changed her. She is, I dare say she's wiser now. I dare say my client's a little bit wiser too than he was. But 2.5 years ago, you have two teenagers who, depending on the version of the story, you believe two teenagers who admittedly made some bad decisions. And the age difference is 3 years, 2 months, and 7 days. We know that God was watching, but because God is beyond the reach of subpoena, you guys have to fill in, and we appreciate you doing everything that you've done. This has been an awful, awful hard week, and this is one that I hope you guys all emotionally heal from. I don't. That is not lost on me, even though I do this for a living. The muck that we've had to wade through this week has been awful, and you guys have been troopers, and we do appreciate that. I do know that there is a very young man who was not legally savvy, who has struggled this whole time to wrap his brain around how the law works, how testimony can be evidence, how one thing can be defined as another thing in the law, and we're supposed to just be okay with that and go with that. And he has put a lot of struggling into trying to understand and wrap his brain around it so he can make decisions, even if some of them are after the fact. Because he's got a lot of living left to do. He's 22 years old. And even in 20 years, he's still going to be a lot younger than I am now. So there is a lot of life left in this young man. There is a lot of moldable clay. We heard from his pretrial services officer that they had issues, they butted heads, but he never threatened her. He always reported in. The things he understands to do, he does well. And on the other things he's learning. If we are going to judge a man, young man, very young man.
2 minutes.
Thank you. We're going to judge a very young man by his reaction to a second-degree felony trial that could potentially brand him forever and keep him away from his dreams. If I were to put myself in his place anytime this week, I would be terrified. What's going to happen? Will I have any of my dreams left? Is it all gone? I still want to share my music with the world. Is there any hope left? Is there anything? There's so much I didn't understand. On retaliation, they tried to introduce evidence of retaliation. Just like I said I would be terrified, he was terrified. He didn't understand what they meant when they were saying about a wagon. He was afraid of mistreatment. He's Black. The officer wasn't. He's heard all the stories. He's not legally savvy. The stories he's heard are probably all the wrong ones, but he believed them nonetheless. He is moldable clay. There's a lot of good in him. There's a lot of talent in him. There's a light in him. Please do not let the dream die, and please do not let the light go out. Please vote for probation for Alexis Morganfield Jr. Thank you.
State.
Thank you, Your Honor. Thank you, ladies and gentlemen, jury, we accept your verdict and we appreciate your verdict and we agree with it. So what we're here for obviously is just to determine what's the appropriate punishment for Alexis Morganfield. And to say brought you evidence. Number one is the retaliation case. Sorry about the technology problems. We will have the dispatch there for you to review. It's about 4.5 hours in, that you can really see him and his reaction. They want to say, oh, well, he just didn't understand. Oh, and he's a black kid. I'm sorry, but he's not Breonna Taylor. He's not George Floyd. Have you heard of any evidence of him, anybody treating him unfair? No. He wants to use that as an excuse for his very, very, very poor behavior. But that's just not what's bared out in the evidence. So you hear him tell the things to this officer who is arresting him per his duty from a warrant. And he acts the fool to that. He starts threatening to beat him up, threatening his family, telling him he's going to knock him out, all of those things for the officer just doing his job. Right? What also do we know about that? Well, when officers show up and go into the room, what's there? Used condoms and underage girls. Okay. I think that speaks for itself. And you obviously can consider for that for what it's worth. Then we brought you Veronica Barta. The reason that we bring her for you is pretrial services is a good indication of how he would do on probation, right? So what do we know about him on pretrial? He is getting arrested for new offenses. He is violating his GPS, which is saying you can go to work, but he's just going to wherever he wants to because apparently he gets to make his own rules. So a good indication of seeing how somebody might act in the future is partially looking to the past. I'm not saying your past defines you, but it certainly gives a good indication of what he's going to be like on probation, right? So is he a good probation candidate? No, right? He's threatening officers, he's picking up new cases, he's not complying with what little he has to do on pretrial because he's just going to do whatever he wants, right? He has that clout, he thinks, because he's a rapper, to do whatever he wants. And then let's talk about Sarah Skidmore for a second. I know that Mr. Cantrell came up here and he said, we accept your verdict. But look at all these things, these terrible things. It was, again, another masterclass in victim shaming. I'm sure she regrets getting in that car. I'm sure she honestly, at the end of the day, she regrets being sexually assaulted. I mean, there's a lot of things that she could have, would have done different. I think all of it can say that about our lives. But to suggest that she had it coming because she got into a car with 3 individuals that she didn't know, it's offensive.
Your Honor, object. I never suggested that in any way.
All right, ladies and gentlemen of the jury, you'll remember the evidence as you heard it, and arguments by state's attorney or defense attorneys are not evidence. All right, you may proceed.
I think you can remember what he said. You know, we have a girl getting into 3 cars that she doesn't with 3 people she doesn't know. Okay, and so she deserves to get sexually assaulted. It's like we had to relitigate a decision that was already made by you. So really what we're here to determine is what is the appropriate punishment. I'm not going to suggest to you a number of years. I think this is a case where you can set the community standard. What is the appropriate number of years? Because either way, even if you give him probation, you have to set a number of years. What we're asking for in this case, and what I think what the state's evidence as far as it relates to punishment is that he does not deserve probation. He's not going to do well on probation. All he's going to do is keep picking up new offenses. And we're just going to be back here again, the state of Texas versus Alexis Morganfield, trying to keep our community safe. And so what we're asking for is jury charges, or the verdict form, unlike guilt innocence, is a lot longer. And so the first one is where you're going to have to put a number of years in. I'm not going to suggest you a number of years. Here, and 2, you have to assess the fine or not assess the fine. In either case, it doesn't matter to me whether you assess or don't assess the fine. What we're asking for is on number 3. And we're asking that you select number D, which is that the defendant's application for community supervision be denied. Because ultimately, I think that is what is appropriate in this case. I think it's appropriate based on the evidence in both guilt, innocence, as well as punishment, is that you've heard a lot about a man, not a boy, that's unwilling to follow the rules. And so ultimately, his application should be denied, and that you should sentence him to prison. Thank you.
All right, ladies and gentlemen, I'm going to send you to the back and you are instructed to deliberate. All right, everyone, please rise for the jury.
Oh, Judge,
Yes.
just want to, the video didn't work. I can't recall if it came in or not, so it doesn't go back there. I was sitting like,
No, the 13th, it was a minute.
Yeah, no, 13.
but it didn't work.
It worked.
Now, it works, but it doesn't work on the equipment out here. So if you all want to review it, you can. But 13 is admitted into evidence.
Maybe see.
All right, Jerry. All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict as to punishment. Is that correct?
Yes.
And is it unanimous?
Yes.
All right, Deputy Laura, if you could pass the form to me, please. Thank you. All right. The verdict form, that jury assess your punishment as 6 years in the prison. There is no fine. And the application for community supervision is denied. Would anyone wish to poll the jury?
Yes, Your Honor.
All right, ladies and gentlemen of the jury, I'm going to ask if this is your verdict in its entirety. And by that, I mean, if it's your verdict for 6 years, your verdict for no fine, and your verdict that the application for community supervision be denied. If this is your verdict, I'll ask you to respond by saying yes. Does everyone understand?
Yes.
All right, and I'm going to start on the front row, on the end. Is this your verdict? Is this your verdict? Is this your verdict?
Yes.
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 Is this your verdict? Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict? All right, ladies and gentlemen, if you will, I'm going to excuse you and have you go back to the jury room, and I will meet you in the jury room. All right. Thank you. Everyone, please rise for the jury. All right, everyone, please be seated.